Dear students, welcome to my YouTube channel, Your Short Questions with Narayan. In today's video, we will be discussing about the intellectual property law, including copyright, patent, the Designs Act, geographical indications, the Trademark Act, and all related intellectual property right laws. This video contains short answer type questions and long answer type questions, which are very important for UGC NET law exam, judiciary exams, Union Public Service Commission exams, IPR attorney exams, and also for your semester exams and 12th class legal studies. So let's start one by one. Discuss in detail the doctrine of fair use. In doctrine of fair use is used in intellectual property laws. The doctrine of fair use is a legal principle that permits limited use of copyrighted material without the need for obtaining permission from the copyright holder. This doctrine aims to balance the rights of creators with the public interest by allowing certain uses of protected works that do not harm the rights of the copyright owner. The Indian Copyright Act allows the following uses of copyrighted material without infringement. One is used for private or personal study, research or criticism. Second is reproduction of work for judicial proceedings or legislative processes. Used in educational institutions for teaching purpose, including creating question papers. Fair dealing with any work not being a computer program for private use, including research, criticism or review. Fifth is reproduction by libraries for archival purposes. Reporting of current events and matters of public interest. They do not fall in copyright. Judicial approach. Rameswari photocopy case of 2016. The Delhi High Court ruled that photocopying copyrighted material for course packs in universities falls under fair use for educational purposes, emphasizing accessibility to education. Second case law is Gramophone Company of India Limited versus Super Cassettes Industries Limited, a case of 2000. The court emphasized that the transformative purpose of the use plays a significant role in determining fairness. Question number 2. What do you mean by intellectual property? Explain with examples. IP, intellectual property, refers to creations of the mind such as inventions, literary and artistic works, symbols, names, images and designs used in commerce that are legally protected to give the creator exclusive rights over their use. IP is intangible in nature and is protected to encourage innovation and creativity. Examples of intellectual property: patents, protects inventions or technical solutions. Example, the patent for the iPhone's touchscreen technology. Trademarks, protects brand names, logos or symbols. Example, the Nike shoes logo and Just Do It slogan. Copyrights, protects literary, artistic and musical works. Example, J.K. Rowling's Harry Potter books. Trade secrets, protects confidential business information. Example is the formula for Coca-Cola. Designs, protects the visual appearance of products. The design of a Ferrari sports car. Geographical indications, protects products linked to specific locations. Example is Darjeeling tea and champagne. Discuss Novartis AG versus Union of India. The facts of this case are: Novartis AG, a Swiss pharmaceutical company, sought a patent in India for its cancer drug Gleevec. This was used to treat chronic myeloid leukemia. Also we can say it was used for liver cancer and lungs cancer. The drug was based on beta-crystalline form of imatinib mesylate, which Novartis claimed was a significant innovation. Patent rejection. The Indian Patent Office rejected Novartis' application, stating it did not meet the requirement under Section 3D of the Indian Patents Act, which prevents evergreening of patents. That evergreening, you must understand, it is the practice of seeking patents for minor modification of known substances, that is colorization or evergreening. Novartis challenged the decision, arguing that the modification provided enhanced efficacy. Section 3D was unconstitutional for being ambiguous and violating India's obligation under the TRIPS agreement. These were the arguments of Novartis. The issue before the court was whether Section 3D of the Indian Patents Act was constitutional and valid, whether the beta-crystalline form of imatinib mesylate demonstrated enhanced efficacy as required under Section 3D, whether India's rejection of the patent violated international obligations under the TRIPS agreement. The judgment on the constitutionality of Section 3D, the Supreme Court upheld the validity of Section 3D, reasoning that it was enacted to prevent evergreening. It encouraged innovation by requiring substantial improvement in efficacy for grant of a patent. Enhanced efficacy, the court ruled that the beta-crystalline form of imatinib mesylate did not meet the enhanced efficacy requirement under Section 3D of the Indian Patent Act. Mere improvement in physical properties, that is better storage or solubility, does not constitute enhanced therapeutic efficacy. Novartis failed to prove that the new form provided greater therapeutic efficacy than the previously known form of imatinib mesylate. The TRIPS compliance. The court clarified that India's patent laws were in compliance with the TRIPS agreement and allowed member nations flexibility to define patentability criteria to suit public health needs. Write a short note on Rameshwari photocopy case. Oxford University Press and others versus Rameshwari Photocopy Services and another of 2016. It is a case of copyright infringement and the use of copyrighted material in educational purposes. Facts of the case. Major academic publishers including Oxford University Press, Cambridge University Press and Taylor and Francis Group. The defendants were Rameshwari Photocopy Services, a photocopy shop located on the premises of Delhi University and Delhi University. The publishers alleged that Rameshwari Photocopy Services was producing significant portions of their copyrighted books and compiling them into course packs or anthologies. These course packs were sold to Delhi University students at low prices without obtaining prior permission or a license from the copyright holders. What were the issues raised? Copyright infringement. Did Rameshwari Photocopy Services violate the copyright of the publishers by reproducing and selling course packs? Fair use doctrine. Does the reproduction of copyrighted material for educational purposes fall within the fair use exception under Section 52 of the Copyright Act? Access to education versus rights of publishers. How should the rights of copyright holders be balanced against the need for affordable access to educational resources? Judgment. The Delhi High Court in its landmark judgment ruled in favor of Rameshwari Photocopy Services and the University of Delhi. The court held that making photocopies of copyrighted material for educational purpose falls under the fair use exception provided under Section 52(1) subsection 1 of the Copyright Act. Educational purposes were given precedence over the commercial interest of the publishers. These words you must remember. Access to education. The court emphasized the importance of education and affordability, ruling that course packs significantly contribute to students' academic pursuits. It noted that prohibiting such photocopying would harm students' interest who rely on affordable educational materials. These are the things you must remember to make your answer. Non-commercial nature. The court recognized that the photocopy shop operated under the direction of the university and did not exploit the copyrighted material for excessive profit. The judgment states that access to knowledge and education should not be restricted by copyright enforcement in cases where the use is reasonable and for public good. Discuss the conditions to be met for an invention to be patentable. For an invention to be patentable under the Indian Patents Act of 1970 and globally, it must meet the following key conditions. One is novelty. The invention must be new and not known to the public in any form, written, oral or otherwise, before the date of filing the patent application. Example, a new drug molecule for treating a disease. Inventive step. That means it should be non-obviousness. The invention must involve a significant technical advancement or feature that is not obvious to someone skilled in the relevant field. A unique mechanism in a smartphone that enhances battery life is an inventive step. Industrial applicability. The invention must be capable of being used in an industry or provide a practical application, a machine that efficiently converts solar energy into electricity. Patentable subject matter. The invention must not fall under the category of non-patentable inventions as specified in Section 3 and 4 of the Indian Patents Act, such as scientific theories, mathematical methods, or atomic energy inventions. Sufficient disclosure. The patent application must clearly describe the invention in a manner that enables others skilled in the field to reproduce it. A detailed blueprint of a newly designed engine is the example. What is TRIPS? Discuss. The trade-related aspects of intellectual property, short it is TRIPS, is a comprehensive international agreement that sets minimum standards for the regulation and protection of intellectual property rights. It is binding on all WTO member nations. The features are comprehensive coverage. TRIPS covers various forms of IP including copyrights, trademarks, patents, geographical indications, industrial designs, trade secrets, and plant varieties. Minimum standards. The TRIPS prescribes minimum standards for IP protection, enforcement, and dispute resolution that all member nations must comply with. National treatment principle. The member countries must provide the same IP protection to foreign nationals as they do to their own citizens. Enforcement mechanism. TRIPS mandates the implementation of effective enforcement mechanism within member countries to protect IP rights, including civil, administrative, and criminal procedures. Flexibilities for developing nations. The agreement allows for certain flexibilities such as longer transition periods and compulsory licensing provisions to help developing and least developed countries adapt to the requirements. Write a short note on plant varieties. Plant varieties refer to a new and distinct plant breeds that are cultivated or discovered through human intervention and exhibit specific characteristics. Different forms existing varieties. These varieties are significant in agriculture, horticulture, and floriculture for enhancing crop yields, resistant to pests and diseases, and adapting to environmental conditions. Key features of plant varieties. First one is distinctiveness. Distinctiveness, this is the one of the key feature. A plant variety must be clearly distinguishable from existing known varieties based on identifiable characteristics such as color, shape, size, or yield. Uniformity. The plant variety must display consistent and uniform characteristics across all plants of the variety. Stability. The variety should maintain its characteristics over successive generations. Novelty. A new variety should not have been exploited commercially for a significant period before the application for protection. Legal protection. Under the Protection of Plant Varieties and Farmers' Right Act of 2001, breeders of new plant varieties can register their varieties to protect their intellectual property rights. This act balances the rights of breeders and farmers by recognizing both innovation and traditional knowledge. Examples: high-yielding varieties of wheat like SD2967, pest-resistant beta cotton. 7. Discuss the concept of patents, including the meaning, objective, and essential criteria of patentability. Explain the procedure for obtaining a patent and analyze its significance in fostering innovation and economic growth. A patent is a legal right granted to an inventor by government providing exclusive rights to use, produce, or sell their invention for a specific period. It is typically for 20 years. It prevents others from using the invention without the patent holder's permission, fostering innovation and protecting intellectual property. What are the objectives of patents? Encourage innovation. It provides inventors with financial and comprehensive incentives by granting exclusive rights. Promote public disclosure. Requires inventors to disclose details of the invention, contributing to the pool of knowledge. Economic development. Enhance technological advancements leading to economic growth. Reward creativity. Recognize and reward the efforts of inventors. Facilitate licensing. Enable inventors to license their invention for commercial use. Essential criteria for patentability. We have discussed it earlier as well. One is novelty. Second is the inventive step, that is non-obviousness, industrial applicability, patentable subject matter. It should not be, the invention should fall within the category of patentable subject as specified by law, machines, processes, or compositions or matter. Sufficiency, of disclosure. Procedure for obtaining a patent. Idea assessment. Determine if the invention meets patentability criteria. First of all, you need to check it. Then patent search. Conduct a prior art research to ensure the invention is novel. Patent drafting. Prepare a detailed patent application including the claims, drawings and specifications as per the formats given by the Patents Office. Filing the application. File the application with relevant patent office. Options include a provisional or complete application filing. Publication. The application is published after 18 months from the filing date. They request an examination of the application to assess patentability. Grant of patent. If the application meets all requirements, the patent is granted. Pay periodic fees to maintain the patent. This is the procedure of filing and patent. Significance of patents in fostering innovation and economic growth. This is the last part of the question. Incentivizing innovation. Exclusive rights encourage inventors to invest time and resources in developing new ideas. Attracting investment. Patents can secure funding by demonstrating the commercial potential of an invention. Knowledge sharing. Public disclosures of patented inventions spreads knowledge, sparking further innovation. Creating economic value. Patents enhance productivity, improve product quality and create competitive advantage for business, thus creating economic value. Global competitiveness. Nations with robust patent systems attract foreign investments and promote global trade. Write a note on biopiracy. Biopiracy refers to the unethical or unauthorized exploitation of biological resources or traditional knowledge, typically by corporations, researchers or entities from developed nations, often without proper consent or compensation to the indigenous communities or countries where the resources originate. Features of biopiracy. Misappropriation of resources. Biological materials such as plants, seeds, and microorganisms are taken without acknowledgement or fair compensation. Exploitation of traditional knowledge. Traditional practices and knowledge such as medicinal uses of herbs are patented without recognizing or rewarding the communities that develop them. Economic and unethical concerns. Developing nations rich in biodiversity are often Developing nations rich in biodiversity are often deprived of the benefits of their resources, leading to economic disparity and unethical issues. Examples of biopiracy. Neem tree. Patent claims on neem-based pesticides by foreign companies despite its long-standing traditional use in India. The turmeric. Patent granted for turmeric, that is haldi's wound healing properties, later revoked after evidence of its traditional use in India. USA had tried to patent these two things, but India's protest stopped it. Basmati rice. Attempts to patent specific strains of basmati rice traditionally grown in India and Pakistan were undertaken, but the strong opposition by India and Pakistan prevented it. Differentiate between passing off and infringement. The meaning. Let's talk about passing off first, then the infringement. Meaning, a common law remedy that protects the goodwill and reputation of a trademark or trade name which is not registered is passing off. A statutory remedy for the unauthorized use of a registered trademark is infringement. This is the remedy available for infringement and this is the remedy available for passing off. Examples. Using a similar packaging to mislead consumers about the origin of goods is passing off. Using a registered trademark or an identical mark without authorization for similar goods or services is trademark infringement. Trademark status protects unregistered trademarks and infringement protects only registered trademark. Nature of right. A right to protect business goodwill and reputation. In the case of infringement, it is the statutory right granted to the trademark owner. Remedies. Injunctions, damages or account of profit in case of passing off. Injunction, damage, account of profit and destruction of infringing goods according to the order of the court in the case of infringement. Burden of proof. Higher as the plaintiff must establish goodwill and misrepresentation. This is the burden is on the plaintiff. Relatively, the burden on the plaintiff is lower as registration serves as a prima facie evidence of ownership. Write a note on traditional knowledge. TK is the knowledge, practices, innovations and cultural expressions developed, sustained, and passed down through generations within a community. It is often linked to biodiversity, environment, agriculture, medicine, and cultural heritage. Characteristics of traditional knowledge: collective ownership. Traditional knowledge is typically held collectively by a community rather than an individual. It is dynamic in nature. It evolves and adapts over time in response to changing environmental and social conditions. Cultural and regional specificity. Traditional knowledge reflects the cultural identity and biodiversity of the region where it originates. Examples of traditional knowledge: medicinal practices, agriculture techniques, cultural expressions. We can talk about Ayurvedic medicine, Unani practices in India. What are the importance of traditional knowledge? Environmental conservation, scientific innovation, cultural identity. Challenges: biopiracy, lack of documentation. Much traditional knowledge remains undocumented, making it vulnerable to misappropriation. Legal protections: what are the efforts? National efforts like in protection of plant varieties in Farmers' Rights Act of 2001 in India, it protects agricultural traditional knowledge. International treaties: the Convention on Biological Diversity ensures fair sharing of benefits derived from TK. It is a global effort. Databases: resources like the Traditional Knowledge Digital Library TKDL, it safeguards the TK from biopiracy. Differentiate between trademark and domain name. What is trademark? It is a recognizable sign, symbol, word or phrase used to identify goods or services of a specific business and distinguish them from others. Domain name: it is a unique web address used to identify a website on the internet. Purpose of trademark: it protects the identity and reputation of a brand in commerce. Domain name: it identifies and locates an entity on the internet. Legal basis: trademark is governed by a trademark laws such as the Trademarks Act of 1999 or equivalent laws in other countries. Domain name is governed by domain name registration policies and ICANN or ICANN regulations. Nature of right: a legal right that protects brand identity and goodwill in the market. Domain name: it is a contractual right obtained by registering with a domain register. Who is the authority to register it? Trademark offices like the IP office in India or USPTO in the US. Domain name registrars accredited by ICANN. Some names are GoDaddy and Namecheap. Duration of protection: perpetual, subject to periodical renewal. Temporary, subject to renewal, usually every 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 years depending on the need of the registrar. Example: trademark is Apple for electronics. Domain name: apple.com for the official Apple website. This is a domain name example. What do you mean by plant varieties? Explain. Plant varieties are specific types of plants that have been selectively bred or naturally evolved to possess distinct characteristics such as resistance to disease, SABHO, adaptability to certain climates, superior in quality, superior in produce or improved produce. If these things are there, then we can say it is a plant variety. These unique characteristics make them valuable in agriculture, horticulture and plant breeding. They are categorized into wild varieties, naturally occurring plants in the wild with unique genetic features. Cultivars, cultivated varieties developed through selective breeding for desirable features. Hybrid varieties, created by crossbreeding two different plant species or varieties to combine the best features of both. The Protection of Plant Varieties and Farmers Act of 2001 in India grants intellectual property rights to breeders for their new plant varieties while also recognizing the right of farmers to save, use and exchange seeds. This legal framework encourages innovation in agriculture and ensures biodiversity conservation. Do an analysis of Bayer versus Natco Pharma. The case Bayer Corporation versus Natco Pharma Limited is a landmark judgment in the context of compulsory licensing under the Indian patent law. What are the facts? Bayer Corporation held the patent for the drug sorafenib tosylate. Tosylate normally is the name of the salt, I think. Sorafenib tosylate sold under the brand name Nexavar, used to treat advanced kidney and liver cancer. The drug was highly priced, approximately 2.8 lakhs per month, making it inaccessible to most patients in India who cannot afford this much amount per month. Natco Pharma, an Indian pharmaceutical company, applied for a compulsory license to manufacture and sell a generic version of sorafenib tosylate at a significantly lower price, which would cost around 8,800 rupees per month. Legal framework. The application was made under Section 84 of the Indian Patent Acts of 1970, which allows compulsory licensing on the following grounds. What are the grounds it grants? The patent invention is not reasonably available to the public. The patent invention is not available at a reasonably affordable price. The patented invention is not worked or manufactured in India. The arguments. The Bayer Corporation's arguments were that it was fulfilling the demand for the drug by improving Nexabar into India, by importing. It was importing the Nexabar drugs to India. Contended that high pricing was justified due to the substantial cost involved in research and development. Argued that compulsory licensing would discourage innovation. The Natco Pharma arguments, it highlighted the exorbitant price of Nexabar, making it unaffordable to most Indian patients, asserted that Bayer failed to manufacture the drug locally and relied solely on imports which were insufficient to meet the demand. It proposed to sell the drug at an affordable price, ensuring wider accessibility. These were the arguments of Natco. What was the decision of the Controller General of Patents? The Controller General granted Natco Pharma a compulsory license. This is the first case of granting compulsory license in India for sorafenib tosylate. The Bayer's failure to make the drug reasonably accessible to the public. The drug's price was not affordable to the majority of Indian patients. Bayer did not manufacture the drug in India, violating the working requirement under Section 84(1)(c) of the Patents Act. Appeals and judgment. Bayer appealed the decision in the Intellectual Property Appellate Board IPAB, the High Court of Bombay, and finally the Supreme Court of India, but all upheld the grant of the compulsory license. The courts emphasized the public interest and the need for affordable access to life-saving drugs. What is geographical indication? State the reasons for their protection. Geographical indication is a type of intellectual property that identifies a product as originating from a specific geographical location where the product's quality, reputation or other characteristics are essentially linked to that location. This is the keywords you must remember. Examples: Darjeeling tea of West Bengal, Mysore silk of Karnataka, Fulbani haldi of Odisha, Banarasi sari of Uttar Pradesh, Alfonso mango of Maharashtra. In India, GIS are protected under the Geographical Indications of Goods Registration and Protection Act of 1999. What are the reasons for the protection? Economic benefits. GIs promote the economic growth of a region by enhancing the marketability and the demand for products linked to that area, often benefiting rural and agricultural communities. Cultural preservation. GIs helped in protecting the traditional knowledge, craftsmanship and cultural heritage by legally associating products with their geographic origin. Consumer trust. GIs assure consumers of the authenticity, quality and unique characteristic of the product, fostering trust and confidence in the market. Rural development. By protecting the rights of local producers, GIs boost employment and livelihood opportunities in rural and remote areas. International recognition. GIs acts as a valuable marketing tool in the global market, providing international recognition and competitiveness to local products. Prevent misuse. GIs prevent unauthorized use of names and help combat counterfeit goods, protecting the reputation of genuine products. Discuss any 5 international treaties, conventions on IPR. Paris Convention for the Protection of Industrial Property 1883 protects industrial property including patents, trademark and industrial designs, features, national treatment, equal treatment for domestic and foreign applicants, right of priority. Applicants can claim priority in member countries within a specified time, that is 12 months for patents, 6 months for trademarks and industrial designs. Prohibits unfair competition. Coming to the second convention, it is Berne Convention for the Protection of Literary and Artistic Works. It protects literary and artistic works such as books, music, paintings and software. Features: automatic protection. Copyright is granted without the need for formal registration. Minimum standards. Authors are granted rights like reproduction, translation and adaptation. National treatment. Equal rights for foreign and domestic creators. Let's come to the third international convention or treaty, that Madrid System for the International Registration of Marks. facilitates international trademark registration, features single application for trademark protection in multiple member countries, simplified renewal and management process. It is administered by WIPO, Patent Corporation Treaty, PCT. It simplifies the process of applying for patents in multiple countries, features single international application with the option to seek protection in over 150 countries, provides an international search report and written opinion to help applicants access patentability. It is administered by WIPO. Trade related aspects of intellectual property rights agreement 1995, what we call TRIPS. It sets minimum standards for IPR protection and enforcement. The features are, it covers patents, copyrights, trademarks, trade secrets, geographical indications and industrial designs. It requires member countries to adopt effective enforcement mechanism. Special provision for public health under Doha Declaration. It is administered by WTO. What is WIPO? Explain its role. WIPO stands for World Intellectual Property Organization. It is a specialized agency of the United Nations established in 1967, which is headquarters in Geneva, Switzerland. WIPO is dedicated to promoting the protection of intellectual property rights across the globe and fostering innovation and creativity for the economic, social and cultural benefits of all nations. Currently WIPO has 193 members. Role of WIPO, promotion of IP right. It promotes the protection and enforcement of intellectual property rights such as patents, trademarks, copyrights and geographical indications across borders. Administration of international treaties. It administers three international treaties like the Patent Corporation Treaty, PCT, Madrid System for Trademarks, Berne Convention for Copyright and the Paris Convention for Industrial Property. Dispute resolution. It provides alternate dispute resolution mechanism including arbitration and mediation for resolving IP related conflicts, particularly in cases involving cross-border issues. Capacity building. It supports capacity building initiative in developing countries by providing technical assistance, training programs and resources to strengthen their IP systems. Global IP system. It facilitates global IP filing systems like PCT for patents, the Madrid system for trademarks and the HUG system for industrial designs, thereby simplifying the process of obtaining IP protection across multiple jurisdictions, means across many countries, across borders. Policy development. It acts as a forum for member states to discuss and develop international policies and standards related to intellectual property. Information and research. It maintains comprehensive databases and tools such as WIPO-LEX and the Global Brand Database to provide access to IP related information and promote knowledge sharing. What are the rights granted to registered design holders under the Design Act of 2000? The rights granted are exclusive ownership. The registered design holder has the exclusive right to apply the design to an article for which it is registered. This ensures that no other party can use, copy or reproduce the design without permission. Protection against infringement. The holder can take legal action against any unauthorized person or entity using the registered design in a manner that infringes upon their rights. Right to license. The holder can authorize or license others to use the design for commercial purposes in exchange for royalties or other benefits. Monetary remedies. The holder is entitled to claim damages or seek an injunction against individuals or entities infringing upon the design rights. Right to exploit the design. The holder can commercially exploit the design by manufacturing, distributing or selling articles incorporating the design. Renewable term of protection. The registered design is initially protected for 10 years, which can be further renewed for an additional 5 years, providing long-term benefits to the holder. Market exclusivity. The holder benefits from market exclusivity by preventing competitors from using the same or similar design, thus gaining a competitive advantage. What is TRIPS? Discuss. The trade-related aspects of intellectual property rights is a comprehensive international agreement that sets minimum standards for the regulation and protection of intellectual property rights. It is binding on all WTO member nations. Comprehensive coverage. TRIPS covers, these are the features of TRIPS. TRIPS covers various forms of IP including copyrights, trademarks, patents, geographical indications, industrial designs, trade secrets and plant varieties. Minimum standards. It prescribes minimum standards for IP protection, enforcement and dispute resolution that all member nations must comply with. National treatment principle. Member countries must provide the same IP protection to foreign nationals as they do to their own citizens. Enforcement mechanism. TRIPS mandates the implementation of effective enforcement mechanism within member countries to protect IP rights, including civil, administrative, and criminal procedures. Flexibilities for developing nations. The agreement allows for certain flexibilities such as longer transition period and compulsory licensing provisions to help developing and least developed countries adapt to the requirement. What should be the characteristic of features of a design? Characteristic features of a design as per the Designs Act should be novelty and originality, applied to an article, visual appeal, industrial applicability. We have discussed it previously in another question, so please refer to that. These are also the not prior publish or use, distinctive and not scandalous, non-technical and non-trademark elements. Write a short note on Rameswari photocopy case. We have discussed it, I think, already. This is a Delhi High Court judgment. Still, let's go for one reading. Oxford University Press and others versus Rameswari photocopy services. It is a case of copyright infringement and the use of copyrighted material in educational purpose. Major academic publishers including Oxford University Press, Cambridge University Press and Taylor and Francis Group at the plaintiff, Rameswari photocopy case and the University of Delhi or Delhi University were the defendants. The publishers alleged that Rameswari photocopy services was reproducing significant portions of their copyrighted books and compiling them into course packs or anthologies. These course packs were sold to Delhi University students at low prices without obtaining prior permission. Yes, let's continue. The publishers alleged that Rameswari photocopy services was reproducing significant portions of their copyrighted books and compiling them into course packs or anthologies. These course packs were sold to Delhi University students at a low price without obtaining prior permission or a license from the copyright holders. Issues raised. Did Rameswari photocopy services violate the copyright of the publishers by reproducing and selling course packs? Second issue is fair use doctrine. Does the reproduction of copyrighted material for educational purpose fall within the fair use exception under section 52 of the Copyright Act? Access to education versus right of publishers. How should the rights of copyright holders be balanced against the need for affordable access to educational resources? Judgment. The Delhi High Court said, the court held that making photocopies of copyrighted materials for educational purpose falls under the fair use exception provided in section 52(1) subsection 1 of the Copyright Act. Educational purposes were given precedence over the commercial interest of publishers in this context. The court emphasized the importance of education and affordability, ruling that course packs significantly contribute to students' academic pursuits. It noted that prohibiting such photocopying would harm students' interests who rely on affordable educational material. Non-commercial nature. The court recognized that the photocopy shop operated under the direction of the university and did not exploit the copyrighted materials for excessive profit. Public interest. The judgment states that access to knowledge and education should not be restricted by copyright enforcement in cases where the use is reasonable and for public good. This is the end of this video. I hope you liked it and found it useful. Please do subscribe to my channel and hit the bell icon to get updates on subjects. Like it and share it. Your comment is vital for me. Do comment. Wish you all the best. Good luck to you. Thank you for watching me. Thank you.